United States, the morality of the death penalty has been an ongoing debate. In this video, we will talk about the Supreme Court case Gregg versus Georgia, which brings up the question, is the imposition of the death sentence prohibited under the 8th and 14th Amendments as cruel and unusual punishment? It all started in November 1973 when Fred Simmons and Bob Moore picked up two hitchhikers, Troy Leon Gregg and Floyd Allen, on a highway in Florida. While at a rest stop in Georgia, one of the hitchhikers, Troy Leon Gregg, pulls out a .25 caliber pistol and kills both Fred Simmons and Bob Moore. The hitchhikers leave the bodies in a ditch and speed off with the stolen car to North Carolina. It just so happens that a third hitchhiker named Dennis Weaver had also been picked up by Simmons and Moore on the very day of the shooting. Luckily for him, he had been dropped off at his destination before the shooting had taken place. Weaver had read about the murders in a newspaper a couple of days after the incident and realized he knew the criminals, and so he decided to help the local police find the suspects by describing the car the men had been driving, and because of this, the two men were picked up by the police just 3 days later. While in custody, Gregg confessed to the murders, but argued that it was self-defense. However, the evidence of the weapon found on him and the testimony from Allen were enough to prove otherwise. Therefore, Gregg was found guilty and convicted of committing murder and robbery and sentenced to death by the state. Gregg didn't believe he deserved this fate and appealed to the Georgia Supreme Court. However, they had agreed with the lower courts, and once again, Gregg appealed the court's decision, this time to the United States Supreme Court on March 30th, 1976. It just so happened that in 1972, a year before the murders took place, there had been a Supreme Court case, Furman versus Georgia, that had effectively placed a temporary ban on all future executions in the country until more guidance came from another court challenge. Because of this previous decision, 35 states wrote new death penalty laws to try and satisfy the Supreme Court's suggestions, 5 of which ultimately led to the Supreme Court revisiting this issue almost exactly 4 years later. The case was in the Supreme Court. 2 amendments came up, both the 8th Amendment and the 14th Amendment. The 8th Amendment says, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. While the 14th Amendment is equal protection under the law. Gregg, his lawyer, argued that the death penalty is cruel and unusual punishment and therefore goes against the 8th Amendment. They argued that the death penalty is too extreme, unfair, and unpredictable, and the process in which it happens gives prosecutors and juries too much freedom. Because of this, some people may get the death penalty while another may not, even though the same crime was committed. On the other hand, Georgia and the other states argued that the death penalty for murder doesn't automatically violate the Constitution, and in actuality, the 8th Amendment evolves with society's values. They said that the death penalty can be an appropriate punishment for murder, and that by allowing death as a punishment, you are essentially helping to prevent future crimes. Using these arguments, the Supreme Court, in a 7-2 decision, sided with the state of Georgia and concluded that the death penalty didn't go against the 8th and 14th Amendment under all circumstances, but more specifically in extreme criminal cases where someone deliberately kills someone else. During these specific cases, the death penalty is okay, as long as the decision is made under good judgment and carefully carried out. The court then established 2 broad guidelines that state legislators had to follow to make sure they didn't pass sentencing laws that went against the 8th Amendment. First, they had to provide objective criteria in order to limit how many death sentences are carried out. And then 2, they had to allow the judge or jury to take into account both the character and record of an individual defendant. With this, the court found that capital punishment, quote, serves as a useful deterrent to future capital crimes and an appropriate means of social retribution against its most serious offenders. While 7 of the justices did agree with this decision, 2 did not. Justice Brennan and Justice Marshall were the only 2 to not agree with the majority. The 2 justices believed that the death penalty was to be invalid under all circumstances. Justice William J. Brennan argued that a punishment must not be so severe as to be degrading to human dignity, whereas Justice Thurgood Marshall stated any individual concerned about conforming his conduct to what society says is right would fail to realize that murder is wrong if the penalty were simply life imprisonment. But what was the impact from this decision? After the decision was passed, saying that the death penalty was, for the most part, okay to have in the United States, executions came back in 1977. And since 1977, more than 8,500 defendants have been sentenced to death, with more than 1,600 having been executed. As of April 1st, 2025, around 2,100 prisoners currently face execution in the United States alone. Since the overturning of the Furman versus Georgia case in 1976, there's been ongoing debates about the ethical and practical implications of the death penalty. Despite claiming the death penalty to be constitutional, the ruling of this case actually slowed down executions. There was a peak in the number of executions in 1999, but since then, executions have been on a steady decline. To this day, the death penalty is a legal punishment in the United States, but only in 27 states, and Michigan is not one of them.